Okay, I would like you to meet a personal hero of mine. His name is Peter Schneider, but today we call him David. And David is extremely stubborn, and he has a vision, an idea. He wants to start a business in second-hand stuff, but he doesn't want to deal with anything boring, dull. No, he wants to do something exciting. So he decides to start a business dealing with used software. And he founds his own firm called, aptly, UseSoft. And David is extremely successful. Why is it that he is successful? It's the fact that he has a very good business idea. Because, of course, there are many undertakings having software that they don't use anymore. And there are other undertakings saying, well, I don't want to spend such huge amount of money on new software. I'm quite happy with second-hand software. So he's very successful. But our David has huge, powerful enemies. And I talk about real enemies like Google, in part, but less. Google, we go back to him later, but much more than that, Oracle, Microsoft fighting our David. And why is it that those Goliaths are fighting our David? Because, of course, what David wants to do is to open a market in secondary market for used software, and they are totally against it because they want everybody to buy new software. You need software, you buy new software. You shouldn't be able to buy second-hand software. And so they are totally opposed to the secondary market for used software, totally against it. And of course, the best way to stop it, to take David to court. And the core legal issue, I'm not going to do much, in depth here, but it has to do with the so-called exhaustion principle in copyright law. This is one of my favorite principles because, of course, we have already mentioned here during the day something like remix, and this is based on fair use. This is another principle limiting the rights of the copyright holders. It means basically that once you are a copyright holder, like a publisher, and you make a copy of your book, okay, and then you sell the book. There is a first sale into the market, okay? You get the remuneration for the copy you have sold, but then you can do whatever you like with your second-hand books. You can resell it. Okay, it's a core principle of copyright law. Nobody has stopped you from selling your second-hand books, second-hand cars, and whatever. It's one of the core principles of copyright law. It's there to protect our freedoms to do things with our stuff, copyrighted stuff, but also, why not, to start new businesses. Okay, but of course, the exhaustion principle belongs to the pre-internet era. Nowadays, we are in the digital world, okay? Everybody's familiar with music files, with e-books, of course, software. And so the question is, do we have a digital exhaustion principle? If you think about it, it's huge. It's about, if you want, buying an e-book from Amazon and wanting to resell it, to create a platform to resell it. Buying a music file and resell it. Why not? We have been doing it for ages with physical stuff. Okay, and of course the case here is Oracle versus UseSoft. And German judges are not very favorable to our David because the Landgericht, first instance and second instance, they say nope. There is no digital exhaustion principle, forget about it. And David was asking, well, why? And the reason is because there is no physical container, because there is no paper, there is no copy, there is nothing like that. So we don't have any exhaustion principle. And of course, in clear legal terms, our David was saying, are you kidding? What's the difference between a paper book and the e-book? You should be able to sell it. And so they say, well, David was also saying, are we stuck to a world of empty boxes? They think about ecology, they think about many other things. So he was really very, very crossed. You know David by now. He doesn't give up easily, not at all. So he went all the way up to the highest court in Germany, and then the German judges actually were not quite in favor of David, but then they decided to put a question to our European Court. We mentioned already the importance of European Union here. We have another example. And the question was, well, it's a little bit more complicated, but to make it easy, does the principle of exhaustion apply also to the sale of software without physical containers? And everybody, I tell you, everybody was expecting a clear answer. And the answer was, we'll see. Okay. So the decision was, the ruling was Usoft versus Oracle, pretty new, July 2012. And quite surprisingly, the judges decided, quite surprising because everybody was expecting an opposite result, decided in favor of our David, who won against Goliath. Well, perhaps it was less dramatic than that, but still, that ruling was able to change copyright law to a small extent. We are not thinking about liberalizing remix or anything like that, not at all, we are not that far, but it's still a small step. Okay, because the judges said, well, in case of software, exhaustion takes place also if the copy has intangible nature. What's the point here? And the other thing is the online transmission, because everything was digital, so the clients were downloading the software directly from Oracle server. The online transmission is functionally equivalent to the supply of a material medium. Is it so difficult as a principle? It took Usoft, I think, in total something like 8 years to get to this ruling, and he almost went bankrupt. So really has been fighting, and that ruling was possible again because of our wonderful European Union. I really want to be, all of us, fans of the European Union. One of the core principles, the free movement of goods and services. Okay, because of that, actually in Europe, we have a much more favorable assessment of used digital files compared to the US, for instance. In the US, there was 2 weeks ago the ruling called REDG saying all those things, forget about them. Well, it's not exactly the same legal issue, but it was not very much in favor of the digital exhaustion principle. What the judge was saying, basically, if you want it, you have to change the law. Okay. From a legal point of view, as a lawyer, I can tell you that ruling, the Usoft versus Oracle ruling, is really at the crossroad of exploration and innovation. Perhaps it doesn't sound so exciting to you. I expect there are much more funny things in life, but to a lawyer, it was like a pleasure to read it. Okay, 2 morals here. The first moral is that copyright law and digital society are not much attuned. I think that in front of me, I think I have many criminals here. Because under copyright law, I would say not all of us, of course, but I would expect some of you to be criminals. So I think, copyright law needs to be revised in depth. And the other thing is that we mentioned it already. At the moment, sadly, I would say, we cannot expect so much movement coming from Brussels. Because, of course, we talk here about directives, perhaps regulations, and Brussels has really become, especially on these issues, copyright and intellectual property in general, a lobby land. Really, it's a very sad status. And not only Europe, I would say also the international level. Of course, I could mention the World Intellectual Property Organization, where things are not much better, I would say. Those guys here, okay, they don't look like innovators, not at all, but they can be innovators. They can be discussing a good case and making a good point. We should not lose faith in those guys. They can be innovators. That was the first moral. The second one is that, well, we are, of course, much in favor, all of us here, of entrepreneurs as agents of innovation. I cherish entrepreneurs as agents of innovation. But those agents of innovation very often are confronted with signs everywhere telling them, well, this very thin ice, very difficult, slippery slope, be cautious, don't do that, okay? So that's especially if those guys talk to perhaps a legal consultant or whatever, very often, of course, they have to be careful. They say, well, you see, it's not very good. This is another hero of mine, Josef Schumpeter. As he was saying quite a few years ago, entrepreneurs are often standing on ground that is crumbling beneath their feet. Okay? Usoft, perfect example. But those entrepreneurs are possessed by the dream and will to found a private kingdom. So Google, for instance, when we started its very successful business that we know all about, it was staying a pretty shaky ground. It was not clear whether the core business model was actually legal under EU copyright law, because it's a fair use principle applying in that case. And at that time, there were no clear ruling about that. But Google didn't care, went for it. And now we actually can talk about Google law. Okay, well, of course, Google should not be abusing its power. We hope that it doesn't. But of course, it has really helped change the law quite a lot, I would say. So books called Google and the Law. So in a nutshell, of course, entrepreneurs here in this room, please do useful things. Okay, do not waste your time damaging other people. Do useful things. Like Usoft was helping small entrepreneurs, okay, not being able to buy very expensive software to have wonderful software paying less. So do useful things. Take excellent legal advice, of course. I don't want you to be, but it's very important, but excellent, but at the same time, open-minded, etc. And then dare it, okay? Because, of course, you will perhaps have to fight. This is a video made by Usoft itself, saying the success story of Usoft. He had to fight a lot, really risking everything, but perhaps your private kingdom might not be out of reach. Thank you.